Hello and welcome to our webinar today. I'm Amy Daly with the Kentucky Regional Extension Center, and our webinar today is all about the new HIPAA Security Rule proposed rulemaking, and we're going to talk about how the HIPAA Security Rule is going to get a makeover. So let's break it down. On January 6th, we were notified that the new proposed rule had dropped, and we're going to see a change in the security rule, which is going to be the first time in a long time that major updates have been made to the security rule. So today's webinar, obviously, we're going to break down the major modifications and the new requirements of this rule. We're also going to talk just a little bit about the history of the security rule. Where did we start with this? What have the changes been along the way, bringing us up to today, and really why we are changing it. And there are several changes with this new rule, and it's important to know where these changes are coming from and what's driving these changes. And then, of course, I'm sure all of you will want to know, well, how long will I have before we have to meet compliance with the new rule? So there's a lot to talk about, a lot to discuss. We're going to start with the history, a little bit about where did we come from with HIPAA security. The very first HIPAA enactment, which was 1996, the birth of HIPAA privacy, that rule set forth the ground groundmaking for the ground rules rather for security. Even in that Privacy Act, it was pointed out that, health information is going to have to be exchanged electronically. And so in 1996, with the enactment of the original HIPAA rule, Congress gave us the ability to enable health information to be exchanged electronically. You fast forward to 2003 was the birth of the actual security rule. And in that security rule, administrative, physical, and technical safeguards were developed to help us as covered entities and understand more about how to protect this electronic health information. From 2003 to 2009, not a lot of change, but HITECH came about in 2009 and pointed to the necessity of stronger safeguards. So we started seeing some definitions of and the expectation of strengthening our safeguards. But one of the important things that the HITECH rule did was it applied the security rule to business associates. So now business associates were subject to HIPAA laws as well, the security rule specifically. 2013, the Omnibus Rule came about and provided greater clarity about what a business associate is. So provided more definition and pointed out that business associates can have subcontractor business associates. So along with the better definitions of business associates, it also gave HHS the ability to enforce action against a business associate or their contractors, their subcontractors, for security incidents that result in breaches. And then 2021 HITECH rule was amended. The hope was to bolster cybersecurity practices amongst all regulated entities. I think there was a lot going on with COVID in 2021. I'm not sure how many of us paid close attention to the amendments that came with the HITECH amendment, but this is how we got to where we are today. So 2013 was really the last major update to the security rule, but even at that time, there were no new requirements. There were no new standards or implementation specifications defined. So we've really kind of been addressing the same security standards since 2003. And even, the word cybersecurity was nowhere to be found in the original security rule. So as you all know, there are a lot of reasons for the necessity of this update to the security rule. And along with, some of what I've already kind of pointed out, but we know that the change is necessary. We know that the needs to be updated. And straight from this proposed rule, HHS is saying we're doing this because there's so many deficiencies that we're observing when we are conducting investigations. We know we've had a significant increase in breaches and cyber attacks. The technology itself is changing. In our environment, in healthcare alone. There are court decisions that are affecting the necessity of an update to the rule. And then this whole thing that we refer to as cybersecurity. And there have been cybersecurity methodologies, practices, procedures, and guidelines that have been published and that we need to implement into our world of information systems to best protect them. So along with what HHS has kind of pointed out as the key drivers for why we're getting this what I consider a pretty major update to the security rule, something that they're kind of hoping to provide is more clarity. They want to provide more clarity, more definition, better understanding of what you as a regulated entity should be doing to meet compliance with the rule. And I would say if I were critical at all of the security rule, that would be probably my top, I guess, criticality, is that the intention originally was to leave it vague so that you could apply more flexibility as you implemented these safeguards. But I guess an adverse effect of that is vagueness leads to uncertainty and lack of clarity. And in one of the places that it's kind of been very misunderstood is the difference between what was required and what's addressable in the security rule. When the security rule was first set out, all of the standards and the implementation specifications that came under those standards were either designated as required, which is pretty straightforward. You must implement this standard and you must comply with each implementation specification, or it was addressable. Certain specifications were considered addressable, and HHS just wanted you to understand that that meant it was flexible. You had a flexible approach. You were allowed a flexible approach as to how you implemented it, but it wasn't optional. And they thought this was clear in the security rule. But as it turns out, 20 years later, their investigations have shown that this one definition or lack thereof has not been clear. And what's happened is we've been misinterpreting the term addressable to mean that it's optional. And so therefore we think we don't have to implement the standard or the implementation specification. So one of the things, a big thing that this rule does is take out the term addressable. There's no longer going to be addressable standards in the rule. Everything will be required. And just keep in mind, flexibility, and this quote is taken straight from the proposed rule. Flexibility is in allowing you to choose the manner in which you meet the standards. It does not mean whether you meet them. So you don't have the choice to not meet them. You just have flexibility. So everything is required now. Also in an effort to provide more clarity and more understanding, at the very front end of this proposed rule, they set out to provide more definitions. There are new terms in the security rule that we haven't seen in past updates to the rule or even the original rule itself. And then there are new definitions being provided for existing terms. So all in all, there are 25 either new or modified terms and definitions throughout this rule. Now, I'm not going to tell you the definition of all of these terms in today's webinar. Just know that it's important to understand the HHS definition of these words when it comes to implementing your safeguards or assessing them, conducting risk assessments, and building your compliance program. You want to make sure you're on the same page as far as your definition and understanding. So this is a slide that I created years ago just to provide kind of a 10,000-foot view of the HIPAA security rule and what's required, the administrative, physical, technical safeguards. And as you can see, there always has been a lot to the security rule. And you can see too that which ones are marked by R for required or the ones that were A, addressable. But this is kind of your overview of it. And when you look at where this is circa 2003 up through today. When you look at that's kind of where the current state of HIPAA security rule. This proposed rule is really providing what you would say is a lot more, right? I look at this as, does this mean there's a lot more to do? Are there a lot of new things? And there are several new requirements that weren't there before. There are also modifications to standards that were already there, but they've kind of rewritten the definition or the way in which you should go about implementing or documenting it. So while it looks a little overwhelming, know that a lot of this was already there and you were inadvertently, I guess you could say, required to do some of this stuff, but now they're making it official. And we're going to get into some of this a little bit more in depth. I don't intend for this webinar to get granular. I really only intend for this webinar to give you an overview of what's new and what's been the things that are changing that will impact you the most. And so these stars kind of outline what we're going to kind of present today as far as the major changes and the new requirements. But again, more granular explanations will come, more training will come. I believe, when the final rule actually or the proposed rule becomes finalized, I think that's going to it'll be a better time to really do a deep dive into a lot of these when we know what they actually finalize. Because remember, right now, these changes are proposed. They have not become final. So we're going to start with what HHS deems. I think it's very apparent when you read this 125-page proposed rule, you really get a sense that this is a cornerstone piece of what will become your new compliance program, and that is your technology asset inventory. This was never written as a requirement in the security rule. As we do security risk assessments for you, we always ask about your inventory, but now it is a requirement and it is the very first part of the security rule. You are required to keep an accurate and thorough written inventory of your technology assets. Your technology asset inventory should include the identification of each asset, the version of the software that you're running or the version of the hardware, the person accountable for tracking that, or maybe it's a department head. Who does this asset belong to, and the location of each of these assets or information system components. So where do each of your assets live? You're also going to be required to create and keep updated a network map. And a network map should represent the movement of EPHI through, into, and out of your information systems. And it should describe the movement throughout your network map. So how does EPHI come into or get created and processed? Where does it get stored? Where does it get transmitted? So On this network map, again, you're going to be reflecting where each of these assets are physically located and if they are accessed through a cloud, for instance. And then maintenance. Maintenance will be required. You will be required to review and update your inventory and your map ongoing, but at least every 12 months or when there's a change in your environment. And this is a good point here, this maintenance implementation specification. When you'll see in the new security rule, they've added a maintenance specification or requirement to almost all of the standards of the new rule. And this is a good thing because one of the biggest questions and one of, I guess, biggest areas of uncertainty with the security rule has always been, how often am I required to do this? How often am I required to do a security risk assessment? How often am I required to do anything? And the word periodically was always used throughout the security rule. You're just supposed to know how often periodically should mean. They have provided more clarity by adding a maintenance requirement to all of the standards of the security rule. And I can tell you that basically when you see the word maintenance, you're going to be required to do it at least annually. And in some cases, more often than annually. I wanted to make that point earlier when we were looking at the overview of all the changes. But as we go up throughout this presentation, I'll continue to point out the importance of the maintenance requirement. So inventory, asset inventory, and network map. How often do you need to update your asset inventory or even your network map? You know, obviously, anytime you adopt new assets, that's going to change your inventory and your map. If you have newly recognized threats or a security incident, when you upgrade, update, or patch, that's going to affect your asset inventory. If you are part of a sale or a merger or a consolidation, that's a major organizational change. That would affect your asset inventory potentially and your network map, or any relevant changes in federal, state, tribal, or territorial law. And these are just examples of when asset inventory should be updated, but it's not an all-inclusive list. So when you come to think about a network map, you know, maybe this is not a technology tool that your IT department currently uses in the management of systems. And so maybe you're going to have to start with just something that looks a little bit like this hand drawing, this rendering, and that's okay. The key is to start somewhere. And if it's pencil to paper and you start, you know, conceptualizing just a visual of what your network looks like, start somewhere. Hopefully, eventually, that map and your renderings will turn into something that maybe is something that you can contain or maintain, I should say, through the help of software systems. So there will be more on network maps. Just know right now you will be required to create, maintain, and update inventory and network maps. Patch management is now something that is will be required in the new rule as well. This terminology was nowhere in the previous or the current security rule. But again, technologies have changed over the past 20 years. And it is time for our security rule to become more technical in nature. With patch management, there are several implementation specifications or requirements that come with this. First of all, you're going to have to create policies and procedures wherein you identify, prioritize, acquire, you know, how you install patches, how you acquire them, how you evaluate them, and then actually performing the actual patch itself. So what are your policies and your procedures? And then again, maintenance, here's this standard. You're going to be required to test your policies and procedures around patch management, and you're going to have to do that annually. And then the application itself. So not only are you identifying when you should patch and how you should patch, but you must apply the patches. And so, you know, a key note here to take away is that they are defining that you will be required to patch a critical risk that has been identified within 15 days of identifying it. A high risk should be patched or updated within 30 days. There are a few exceptions to this new standard. So if a patch is not available for your system, or in a case where a patch would adversely affect the confidentiality, integrity, availability of the EPHI. And the rule goes into more detail about patch management, but remember, I just want to give you kind of the basic, the high level of what's going to be required. There will be time for us to go granular throughout the remainder of this year, and of course, when the rule gets finalized. I am not surprised at all, and actually I'm quite delighted that the new rule, if finalized, will provide more clarity and more definition around security incident procedures. Specifically, the new rule will say that you are required to have a security incident plan. You will be required to test that plan, and you will be required to have an outline of what your response to a security incident would look like. So when you're developing your plans, and I have provided for the past 3 years now different resources for creating security incident plan templates. And again, just like a network map, you just need to start somewhere, but they have to be written. Maybe it's something that looks like a ransomware playbook, but you have to have a plan in place. So things to remember when you're writing your plan, you're going to want to take into consideration, how will your workforce members report either a known or a new security incident? How will you as an organization respond? Who's a part of your team, your incident response team? How will you plan? How will your plans and procedures be tested and then ultimately revised? Are you going to conduct tabletop exercises annually? And then you have to review and test them at least every 12 months. You've got to document and modify your plans from the outcomes of your test. And I just came back from the Global HIMSS conference, and I will tell you that there were executive leaders from the Mayo Clinic, from other networks, other hospitals that are nationally known, and they talked extensively about conducting tabletop exercises as a starting point and the profound benefits that have come from getting these tabletops put together and implemented. And I loved hearing about the success of those tabletop exercises. And those tabletop exercises graduated into actual tests of where they would isolate and take down one, maybe the business office or one portion of a clinic, and actually for restoration efforts and for testing efforts, shut down all systems and then perform a restoration test. So it was great information, and I can't wait to have more conversations with each of you about the things that Lindsay and I learned while we were at HIMSS. But security incident procedure and planning is a big deal and a big part of this new rule. So when it comes to response, they follow NIST standards. You need to be able to actually respond to the incident that you have according to NIST standards, which say you need to be able to identify and respond to the incident. You need to be able to mitigate it. You need to be able to remediate it, eradicate it. And then once you get through the process, you're going to document what happened throughout the course of the investigations, any analyses that you performed throughout, your mitigation efforts and your remediation efforts, because you're going to learn from it. And so you're going to update those plans. It is a cyclical, ongoing process, part of your compliance program. New updates to the contingency plan. Contingency plan has always been part of the security rule. But there are a couple of big changes now that are required as it relates to your contingency plan. First of all, you've always been required to perform a criticality analysis. I put this as part of this presentation to draw attention to the importance of it. You need to know the criticality of your systems. Which ones are the most critical? Which ones should you be able to bring back up first? And so you really may think that you know, but when you involve all areas of your organization, what IT believes are the critical systems may not be what the ER or the dietary group thinks are the critical systems. So it's going to take a group effort here to identify the critical systems. But that plays into this next part. The new rule will require you to build into your disaster recovery plan the ability to restore data and critical data and critical relevant electronic information systems within 72 hours of the loss. And that can be quite intimidating. So that criticality analysis is a key part of being able to restore within 72 hours. And when you think about ransomware attacks and all that we've seen, even in Kentucky, can you imagine, you know, the necessity to be able to report to HHS that you got your systems restored in 72 hours? We know that sometimes this has taken months. But there are a lot of factors that are going to go into play to get us ready to be able to respond to a ransomware attack and recover within 72 hours. I want to point out, though, this says critical systems. So you will need to be able to say, I've identified these are the critical systems, and this is how I'm going to be able to bring them back up. You're going to do that through testing and revision. And so testing and revision, again, has always been part of contingency plan, but now the security rule tells us exactly how often we should be doing the testing and the revision. So once every 12 months, you will have to document that you've conducted a test and you've revised your contingency plan. Brand new, this is a brand new requirement with the security rule. It's called a compliance audit. So the security rule currently, the proposed rule says that you will be required to perform and document an audit of the compliance with each of these standards and implementation specifications of the security rule, and you'll be required to do so every 12 months. But really, that's all it says. So I'm looking for, in the final rule, I am looking for some more clarity and for them to expand upon what they are really looking for here. But what we do know, and this is written in the proposed rule, is that they are suggesting that this audit is conducted independently from your information security management team. So in other words, your IT team or your security management team would not be conducting this compliance audit. Maybe a different group within your organization conducts the audit. They also are saying that an audit should provide independent and objective assurance and advice on all matters related to the achievement of each of the objectives. So that's the goal of a compliance audit. It's looking for objective and independent assurance on each of the standards. Do you have them in place? That's how I interpret this. We're not gauging risk. This is not a risk assessment. This is basically looking at, are all of the standards from the security rule in place? Have we accounted for them? And is there anything that we need to know about that? You know, or do we have all policies and procedures in place? And then they do point out that the audit can be performed by you internally or by an external party. So again, I'm looking for more guidance on this. I'm wondering if, you know, this wouldn't be something more like a checklist, not just a checklist. I mean, there will be some depth there to it, but it's definitely not the same as a risk assessment. They do provide this resource documentation from U.S. Government Accountability Office. I have looked at this document. This document is 104 pages. It's incredibly detailed and helpful when it comes to understanding how to conduct an audit. So I've provided here as a resource. the compliance officers in the group, the HIPAA security officers and privacy officers, when you have time, I do think that it would help go a long way if you would check this document out that explains more about audits. Something else that's coming down the pike with this new rule is business associate contracts and the agreements that we have in place with business associates. So we've always been required to have a business associate agreement in place. And business associates, like we said earlier, since 2009 have been subject to the security rule, which means they were supposed to be doing their own security risk assessments. But through these investigations and breaches that have happened, especially over the past 4 or 5 years since COVID, what HHS has found is that business associates aren't protecting or safeguarding the way that they should be, our EPHI, even though they've signed an agreement, and they're not conducting security risk assessments. So this new provision would mean that we have to obtain a written verification from our business associate at least annually that they do have technical safeguards in place, that they are conducting an analysis of those safeguards, and that they can provide us with a written certification that the analysis has been performed by a person who has the authority to do so. Now, I am looking for more guidance with the release of the final rule on this, but right now, just know that you are going to have to obtain written verification annually that your business associates are holding up their end of the bargain, which means they have technical safeguards in place and they're doing their own risk analysis. This also will mean that you need to update your business associate agreements. We haven't had to update business associate agreements since the Omnibus Rule of 2013. So here we are almost 12 years later, and not only is the security rule getting a makeover, but our business associate agreements will be getting a makeover. You're going to have to include at least these 3 new provisions into your agreements. These provisions are going to ensure that subcontractors of your business associates are also complying with the HIPAA security rule, and that your business associates are entering into agreements with their subcontractors. It's going to be a provision that requires that the business associate reports to you, if you are the covered entity, a security incident. So that's been a requirement, but now there's, what the security rule is saying, you've got to include this into your business associate agreement. The provision must state that your business associate will notify you per the breach notification rule of any security incident or breach that has happened of unsecured EPHI. That CFR 164.410, that relates back to the breach notification rule and the provisions for business associates to report that out. But you've got to include this in your agreement now. And then the other thing, and this is really new, that the business associate has to report to you if they've activated their contingency plan. So without unreasonable delay and no later than 24 hours. So if they've activated a contingency plan, they have 24 hours to notify you. So I just kind of want to point out something here. The breach notification rule says that the business associate has 60 days to notify you of a security incident. But I think this is HHS kind of maybe circumventing a little bit by requiring them to notify you the activation of their contingency plan 24 hours. It's kind of circumventing that 60-day rule, because here's the thing. If they have a security incident, they now are going to have to implement their contingency plan. And if they implement their contingency plan, they're going to have to notify you within 24 hours. So this should mean long gone are the days that they don't notify the covered entity of a security incident or a ransomware attack, for instance. They're pretty much going to have to let you know within 24 hours. So this is a good thing, but we've got to capture this in our business associate agreements. All right, access controls have been a part of the security rule since the beginning, but something that's new is the distinguishing rather between administrative accounts and all other accounts. All right. So what the new proposed rule is saying is you will be required to separate user IDs, workforce member user IDs, from administrative IDs. So if someone works for you who has admin privileges to different systems or maybe all systems in your network, they are also required to have a separate user ID that is separate from their admin ID. So just think of it as this. If you are an admin privileged user, you should not be using your admin account access to do your everyday work and access systems. You should only be using admin user IDs to perform the task at hand. If that is patching something on your network, if that is conducting an audit that only an admin level account would be able to have. But for everything else, you go back to using your regular system user ID that maybe has more privileges than other people, but it's not an admin account. This is very, very important because many of the breaches that HHS has investigated have come from admin level privileged accounts. And so there has to be a separation there. And then network segmentation is a requirement of the proposed rule as well. Never before have we talked about network segmentation in the security rule. We talk to you about it when we're doing your security risk assessment. We've known all along that it was going to come to this when it comes to new technical controls, but now it's in black and white. It will be required that to the extent that is reasonable and appropriate, you must segment your network and all of the relevant electronic information systems. Encryption and decryption, some updates there. We know that that's been a part of the security rule, but it's always been addressable, right? And so, years ago, when I would do security risk assessments, it was very common for me to see that laptops are still going out and going home with workforce members, but they're not encrypted. And I think we're getting closer and closer to that not being the standard, but it was addressable, right? And so everyone thought, well, it's addressable. And we misinterpreted that to mean, well, it's optional. So I'm not going to do it because it's expensive. But now know that encryption is required. And not only is it required, it's required on all EPHI at rest and in transit. So this isn't going to be an easy feat, and I know, and it could be somewhat costly. We'll wait and see what the final rule says, but right now they're calling for all EPHI to be encrypted at rest and in transit, with a couple of exceptions. If the technology asset does not support encryption, or if a patient is requesting their EPHI be transmitted to them in an unencrypted manner. So that's kind of a rights of access under the privacy. So right now, those are the only exceptions, and there will be more at a granular detail level to come about this later. But right now, just know that's what it's proposed, that we get all of our data encrypted. Configuration management is something that is new. We're really getting technical with this rule now, and again, I think that it's necessary. So the configuration management has a couple of implementation specifications or requirements as part of that standard. One being configuration. They call it just configuration, which means you've got to remove unnecessary software from your systems. So software that is no longer used, it's obsolete, maybe it's older applications that are no longer supported with patches. I think they're kind of getting at legacy systems here, which is, that's necessary too. But you are going to be required to remove those. If you don't remove them, they will be required to be segmented. And if you're not segmenting, then you're going to be required to document the reason why, is what it's going to come down to. And then network ports, you are required to identify the ports in use and the ones that are not in use, and you will be required to disable anything that is not in use. So disable network ports in accordance with your risk analysis. So through your risk analysis, you should be identifying, just something that comes to mind, a couple of facility walkthroughs that we conducted last year. We look for network ports always, and I will always ask, are those ports live? And usually I'm asking when they are in public areas, maybe a treatment room or in a hallway. And many times we find that those ports are live, and right there during the assessment, the systems engineer will go back and disable those ports. So just know that's part of the rule, and it is something that needs to be accounted for and assessed along the way. Authentication. So multi-factor authentication will be required. And as the proposed rule is written, it says it will be required for all technology assets in your relevant electronic information systems. So multi-factor is just verifying that a person seeking access is the person that they claim to be. And you may have implemented this in some areas or on some applications in your organization. Right now, it's looking like we're going to have to implement across the board. So I'm sure there will be some pushback against that. With these proposed rules, the public is allowed for 60 days to submit comments. And Lindsay and I, actually Lindsay just checked yesterday and said that she told me they've received over 4,000 comments. And so they're going to have a lot to go through before they finalize this rule. But right now, multi-factor authentication has made its way into the technical safeguards of the security rule. Okay, so this one's big too, vulnerability management. Under the new rule, you will be required to conduct vulnerability scans, and you will be required to do them at least twice a year, once every 6 months. You will also be required to conduct a penetration test at least once every year. And that penetration test must be performed by a qualified person, which HHS has deemed a person with appropriate knowledge of and experience with generally accepted cybersecurity principles and methods. It will be interesting to see how it plays out that we verify that a person has that knowledge. And again, hopefully that will be provided with the final rule, but just know penetration testing will be required, vulnerability scanning will be required, and they've provided the frequency with which you're going to have to do those, conduct those tests. All right, data backup and recovery. So it's a good thing how they've kind of broken down data backup, because with the current state of the security rule, there are, I think, 3 different places where data backups get mentioned. And I think that it has provided a lot of confusion. And so they're bringing this into a couple of areas. We've got this one new standard called data backup and recovery. This pertains to data. Remember, data. So your backups, you should be conducting backups of data at least every 48 hours. You should be conducting real-time monitoring and alerts for failures or errors of those backups. You should be documenting that a backup was successful or it failed or any other error that happened during the backup, and then testing. And if you've been working with us for the past few years on your security risk assessment, you know that we've been asking for and pointing you in the direction of testing, even though testing your backups was not an explicit requirement of the security rule. HHS assumed that you've been doing these tests, but now they want to make sure that there's no you cannot mistake the fact that your backups should be tested. And not only are you required now to test them, but they're saying you should do it monthly. So conduct a restoration test using backed up data and document the results of those tests at least monthly. Now, again, remember, this standard is specific to data. Something that was not really brought up in the current state of the security rule, but now is very clear with the proposed rule, is not only should you be backing up data, but your information systems should be backed up as well. So they've created a new standard, information systems backup and recovery. And they say you should create and maintain backups of not only your data, but your relevant electronic information systems. And inasmuch, you should review and test the effectiveness at least every 6 months, which means conducting a test every 6 months, restoration procedures on your systems backup and recovery. And again, we've been talking about this for at least the last 3 years at every security risk assessment that we go to. We know that your data is more than likely at this point in 2025 backed up to a cloud, and you're using cloud services, and it's probably through your cloud-based EHR. But what we're not seeing is that we don't have processes in place to address the rest of our systems. And we know that when a ransomware attack comes, it takes out, sometimes we can't even get to see the data, whether or not it's been encrypted, because we can't even get in the front door of our own computers and through our initial systems. So everything must be backed up and it must be tested every 6 months. So data monthly, information systems backups every 6 months. All right. So that was a look at all of the most significant changes and the new requirements that are coming, if finalized, but that have been outlined in the proposed rule. And that brings us up to, all right, how long will I have before I have to become compliant with the rule? We don't know when the final rule, because that's what we're waiting for now, we don't know when that final rule will be published. What we know is that the proposed rule was released January 6th. Everyone had the ability to submit a comment for 60 days, which closed on March 7th. Now they are reviewing comments, and we don't know how long it will take before the final rule gets published. But once it does get published, what we do know is that what HHS considers as the effective date will be 60 days after publication. The compliance date will be 180 days after the effective date, which gives you a total of 248 days from the published date to become compliant, which is about 8 months. So let's just plug in some dates here. Again, these are pretend dates. So if the final rule gets published on October 31st of this year, it would become effective 60 days after, which would be December 30th of this year, and you would be required to become compliant by June 28th of next year. So again, those are hypothetical dates. We do not know, but just to give you an idea, you would have about 8 months. And they make it very clear that at least their plan is to stick to this 240-day timeline. I don't know if commenters will be able to persuade them otherwise. There are there's one main caveat to this whole 248 days, and that's as it relates to your business associate agreements getting updated. So there is a part of the rule that's called transition provisions, specifically addressing the timeline you will have to update your business associate agreements. And I want to be able to explain this to you without confusing you. And I think the best way to say this is if we take the effective date, the hypothetical effective date from the last slide, the effective date is potentially December 30th. So if that were true, your compliance date's June 28th, 2026. This new rule is saying that you have until either 1 year after the effective date, or if your business associate renewal, the business associate agreement is supposed to become or expires and becomes renewable before that 1 year, then you have to update your agreement, get it signed by your business associate within that 1 year timeline. So, which would fall between the compliance date and the 1 year timeline. Otherwise, if the renewal date for your business associate agreement falls after the 1 year timeline, you have to have everything updated by December 29th. I know that's confusing. I don't think I did a very good job. I think the best thing from the way to put it is you're going to have until 1 year after the effective date of the new rule. I've worked with most of you on your risk analysis and reviewing your business associate agreements. Your business associate agreements were updated with the Omnibus Rule of 2013. And I think that in most cases, those are what would be considered evergreen contracts. They typically don't come up for renewal with a business associate agreement. So most of you what's going to apply is that you would have that 1 year time frame to become compliant. And the only thing is if you do have an agreement that falls between the 1 year date and the actual compliance date, then you would need to renew it before that 1 year. I promise I'll help you understand that better afterwards if this example didn't help. But I think most of you will fall within that. You'll have 1 year after the effective date. All right. So I just wanted to provide a few resources. These were actually taken from the proposed rule. These were cited throughout the proposed rule. NIST standards. NIST is heavily referenced to in this new proposed rule. What I can tell you is that if you're following NIST standards, then you're going to be okay when it comes to this security rule, because HHS is relying strongly on guidance and directive from NIST. Also, the new HHS 405D program, if you don't know about this or aren't familiar with their website, they have really good cybersecurity resources there, and they refer to this specific document, Health Industry Cybersecurity Practices. The FTC, they also refer to this guide, this Start with Security, a guide for business. I haven't read it, but I've skimmed it. I think it's good basic knowledge for starting up cybersecurity. And then the CPGs that were released about a year and a half ago from HHS, your technical group will find those very helpful, because most of what's changing in the security rule, as they promised, are aligning with the CPGs that were released back in the end of 2023. Well, my hope is that you come away from this webinar knowing the biggest changes that this rule seeks to implement. You can reach out to me with questions, email me, or you can also reach out through, let me bring you up to our contact slide here. We're on Facebook. We do have an email and Twitter and LinkedIn account. So reach out with any questions. And I do want to take you back here just to let you know that we do conduct security risk assessments. We have a project management service line and vulnerability scans as part of our HIPAA services. But we also offer PCMH, PCSP, QPP, value-based, and quality across physician services and hospital services. So if there's anything we can do to help you along those lines, please reach out. And again, I'll bring the contact site up. And just know that we are going to stay on top of any releases and information that comes out after the release of the final rule. And obviously, when it gets released, we will have more training coming to you so that we know exactly what we have to do for our HIPAA security compliance program. I look forward to working with you and talking to you soon. Reach out with any questions. Thanks for participating in our webinar today.